Hi everyone, thank you for joining me this afternoon to talk about parenting after separation and mediation. A little bit about myself. I'm an associate at Michael Lynch Family Lawyers. There's a little bit about the firm. We also publish regular articles and other publications, including newsletters. Most of you are probably signed up to receive our newsletter, but if you're not, please just send us an email and we'll add you. Here's an overview of what I'll be talking to you about this afternoon. Firstly, the law that governs family law issues, legal terms for parenting, different types of parenting issues that arise in family law disputes, pathways to resolution, the role of counselling and mediation, some common terms used in family law matters, and some practical tips. So the scope of family law is really quite wide. Just some of the issues that we deal with on a day-to-day basis include separation, divorce, property settlements, parenting arrangements, that is, who the children live with, spend time with, child support, spousal maintenance, domestic violence, relocation, which refers to when one party wishes to relocate a child's residence far enough away from the other parent so that it will impact on that child's time with that parent, paternity, change of name, and international child abduction. So what is the law then in relation to family law matters? The overarching legislation is the Family Law Act 1975. It is Commonwealth legislation, which means that family law matters are dealt with the same way, using the same legislation in all of the states of Australia, except Western Australia, who haven't referred their powers to the Commonwealth. So it covers all children's matters and all property settlement matters. It is amended from time to time, and as solicitors, we need to ensure we keep on top of those amendments. The two main courts that deal with family law matters is the Federal Circuit Court and the Family Court. Federal Circuit Court was established in 1999 and was originally known as the Federal Magistrates Court. It was designed to deal with less complex family law matters and to give parties a quicker, less adversarial way to resolve their disputes. The Family Court tends to deal with more complex property matters, as well as matters where there are child sexual abuse allegations and international child relocation matters. Domestic violence is state-based legislation and is dealt with in the Queensland Magistrates Court. Some legal terms for parenting under the Family Law Act. These terms change from time to time. Pre-1996, the terms that were used were guardianship, custody, and access. But post-1996, they changed to residence, contact and specific issues. Now, and since the 1st of July 2006, the terms that we use are lives with, that is, who does the child live with, spends time with, or substantial and significant time. And the other term that is used is equal shared parental responsibility. Just a little bit about that last term, equal shared parental responsibility. It is in fact a presumption under the Family Law Act in all children's matters that there should be equal shared parental responsibility. It is, however, a rebuttable presumption. So that means, in short, It's a term used to describe both parents' ability to work together to make decisions about their children's lives, including long-term decisions such as schooling and medical procedures. This presumption is not to be mistaken for the time that a child spends with either parent. Some more information about the types of parenting issues. So that first one is usually the one that parents are most concerned about when they separate. That is, what physical time will their child be spending with each of them? Is it weekdays? Is it weekends? What happens during school holidays and other special days? Or is it the case that time should be supervised? Communication between a child and parent is also something that is important, especially if they're not seeing that parent for a week or 2 weeks. That communication might be by telephone or Skype or FaceTime. Some other issues that arise in parenting matters. What religion should the child be following? Are there any cultural issues? For example, does the child have an Indigenous background? What school should the child attend? What about the child's name? Can the child's surname be changed for any reason? Just touching on the surname issue, that's a hard one for the courts to decide, but the things that they have to refer to when deciding that type of application, firstly, the welfare of the child is always their paramount consideration. The next, they look to the short and long-term effects of any change in the child's surname on the child, any embarrassment likely to be experienced by the child if the child's name is different from that of the parent with custody or care and control or who they live with. Any confusion of identity which may arise for the child if his or her name is changed or is not changed. The effect which any change in surname may have on the relationship between the child and the parent whose name the child bore during the marriage or relationship, and the effect of a frequent or random changes of name. Other issues can include travel by a child overseas with a parent or the issue of a passport. Often disputes arise when a contact parent or a parent who the child only spends time with seeks to travel on a holiday overseas with the child, and the primary carer or the parent with whom the child lives does not agree. In one such matter, there was a father who was seeking to travel with a child on a 3-week holiday to the United Arab Emirates. The United Arab Emirates is not a signatory to the Hague Convention. The Hague Convention is a treaty between Australia and a number of other countries that provides for the lawful return of abducted children to their home country. The child in this matter, who was 13, had expressed a strong wish to go on the holiday. The court carefully considered the risk of the child not returning to Australia in light of the existence of continuing ties that the father had to Australia. The court found that although there was some basis for concern by the mother, in balancing all of the factors, it was in the child's best interests for him to enjoy a short holiday with his father in the United Arab Emirates. The court was careful to ensure that there would be a number of conditions the father would have to comply with to ensure the prompt return of the child to the care of the mother in Australia at the end of the holiday. And one of those conditions was a significant bond payment. The father was ordered to pay a bond of $100,000. The court found that that was sufficient to entice the father to return the child at the end of the holiday, and also would be adequate enough to provide for any action the mother may need to take to endeavour to obtain the child from overseas if the child was not returned. So next I want to talk about the different pathways to resolving family law matters that involve children's issues. First and foremost, I think everyone should obtain advice. Clients need to have knowledge about how the Family Law Act would deal with their matter. Then, once they have that advice, they can either negotiate themselves or use a solicitor to negotiate on their behalf. If they're able to reach an agreement with the other person, then there can be a parenting plan prepared, which I'll talk about in a minute. Another option is a consent order. They may seek to mediate, but if there's no resolution, they may need to make an application to court. So next I'll talk about each of these pathways and give you an overview. Remembering also that verbal agreements can sometimes be enough. Some parents can continue to co-parent without the need for anything formal in place. This means they're really putting aside their own emotions about the separation and working together to discuss their children's needs. It does allow them some flexibility. A parenting plan is basically a written agreement signed and dated by both parents setting out the care arrangements for their children. Now, one of the main pros of a parenting plan is that it allows parents to be flexible. But by writing it down, it's a useful tool for ensuring that both parents are on the same page about their children's care arrangements. In my experience, it's particularly suitable when there are very young children whose needs are changing constantly. A parenting plan can be prepared with minimal cost, as parents can prepare it themselves. Alternatively, perhaps a family dispute resolution practitioner that they have seen together can assist in the preparation of the plan, or they can come and see a solicitor and it can be prepared. However, it is not binding on either party. Therefore, if one person decides not to follow it, the other person really has no recourse against them. Further, a court is not bound to follow a parenting plan. However, a judge may have regard to a previously prepared parenting plan when deciding a matter. It's really just one piece of evidence a judge will have regard to. The next thing I'm going to talk about is consent orders. Consent orders are the result of a negotiated agreement between the parents. Parents can negotiate by themselves or with the help of a solicitor. If they're able to reach an agreement, it can then be formalised, and that's done by preparing two documents which are then filed in the family court registry after both parties have signed them. The first document is the consent order. That's the order that really documents what the care arrangements are going to be that the parties have agreed upon, as well as some of those other issues I described earlier. For example, travel overseas, what school the child might attend, etc. The other document is an application for consent orders. That sets out what's happening with the children presently, information about what school they attend, are they in good health, what their ages are, etc. And that enables a registrar to consider the order that the parties seek that the court make to ensure that it's going to be in the children's best interests. So once an order is made by the court, it can only be changed by further order of the court or consent between the parties. So this means it's in place until the children turn 18 years of age. So what can consent orders cover? As I discussed, it's the concept of parental responsibility. Is it equal shared parental responsibility or sole parental responsibility? the time that a child is to spend with both parents. So this can be any variety of arrangements, from living with one parent most of the time and spending weekend time or overnight midweek time with the other parent as one example, or maybe it's an equal time situation, maybe week about or a split week where a child spends equal time with both parents. The order can also provide for what is to happen on special days, school holidays. Now, consent order can also deal with parents' behaviour. It can seek to restrict a parent from consuming alcohol whilst a child is in their care, or maybe 24 hours before a child comes into their care as well, as one example. It can also deal with the provision of information to ensure that both parents are being fully informed about children's schooling, medical issues. So unfortunately, not all parties are able to negotiate an agreement. So there are many reasons why parents might resort to making an application to court for a judge to make a decision about what is in their child's or children's best interests. Those reasons can include urgency or antisocial behaviours being shown by one or both parents, for example, drug use. Maybe there is domestic violence in the relationship, and the list goes on. It's worth noting that court is not a quick fix. Due to the number of matters before the court and the delays in the court system, parents can be waiting a number of months to even get their first return date. Parents need to remember that when they make an application to court, they're handing over the decision-making process to a third party, that is the judge. The judge doesn't know them and doesn't know their children or their family situation. So this slide just talks about the time frames. So from when an application is first filed in the court, you can wait up to 3 months to get your interim hearing date. And I'll talk about what an interim hearing is in a moment. But after the interim hearing, you can wait an estimated 18 months before a final hearing. Once a final hearing's been heard by a judge, the judge can reserve their decision about the final hearing, and then parties are waiting for a further amount of time. And that can also be a significant wait. For example, 12 months, 2 years. Next, I want to talk a little bit about family dispute resolution. It's a mediation process undertaken by parents with a registered family dispute resolution practitioner. As you might all know, not all counsellors are family dispute resolution practitioners. They're practitioners who meet the accreditation standards and are approved by the Attorney General's Department. There are many family law lawyers and barristers who specialise in family law that are approved family dispute resolution practitioners. The options for attending family dispute resolution can either be at a family relationship centre across Australia, who are operated by different contracted organisations, or you can attend upon a private family dispute resolution practitioner. There are delays with attending the centres, I've found, and sometimes it is quicker to see a private practitioner. So why then is family dispute resolution important? Before a parent can make an application to court seeking orders about children, they must hold a current Section 60I certificate. A Section 60I certificate is a certificate issued by a registered dispute resolution practitioner. So what would happen is the parent would make contact with a family dispute resolution practitioner. That practitioner then assesses if the matter is suitable for family dispute resolution. If they deem it suitable, they'll then contact the other party and invite them to attend the family dispute resolution. The other party may then attend or ignore the request. At the end of the process, the family dispute resolution practitioner will issue a certificate to the party or parties, and then the party wishing to make an application to court must file a copy of that certificate as part of their court application. So why then does the court need the certificate? The courts are extremely busy, leading to long delays. The courts are hoping that by having this process in place as a pre-action procedure, parents will try to work out their disagreements first without feeling the need to rush off to court. There are exceptions to the rule about filing a dispute resolution certificate. If there is some urgency about the matter, or if there's some domestic violence, then a party is able to file an affidavit of non-issue of a family dispute resolution certificate, setting out why they don't have or cannot obtain a certificate. A registrar of the court will then assess the matter based on the information they have before them and decide whether or not to permit the application to be filed without the dispute resolution certificate. What I'm experiencing currently is that even if there is domestic violence in the matter, many of the dispute resolution centres and private practitioners are actually set up to handle that situation so that parties aren't seeing each other, for example, so that they can still attend the process even if there has been some domestic violence. But really it will depend on the resolution practitioner as to whether they think it's suitable or not. Next, it's mediation. Parties don't have to mediate. It can be voluntary. However, if they're in the court system, sometimes the court will make an order for it. It's helpful to be prepared for mediation before you attend to get the most out of it. So make sure you've worked through what options you see as working in the future. If it's a property mediation, make sure you've got all the information and disclosure you need. You can have a legal representative at mediation, and in my view, that is entirely helpful, but parties can attend by themselves. There are different types of mediations. For example, the shuttle mediation, round table mediation, or dual mediator. The one that is most used in family law is the shuttle mediation. So that is where a mediator shuttles between the parties that are in different rooms. So they go between the two rooms conveying offers. It is a confidential process unless there is a threat made to someone. So as I stated before, it's voluntary unless it's court ordered. It's confidential. So this gives parties the ability to discuss the matter openly and convey offers between them without the fear that if an offer is not accepted, it might be raised later on in court. It's a flexible process. It's not binding unless at the end of the mediation the parties agree to do heads of agreement leading on to a consent order. The parties are really responsible for making their own decisions in a mediation, with obviously the assistance and advice from their legal representative if they have one. The role of the mediator. The mediator is neutral and impartial. In fact, many mediators will really make a point of spending the same amount of time in both rooms to ensure that parties realise they are neutral. They're really there to facilitate the parties' discussions. They don't adjudicate and they don't make decisions. Obviously, the hope is at the end of the mediation that if the parties are able to resolve their dispute, and if they can, what's usually prepared in family law matters at the end is a heads of agreement, which can be quite loosely drafted, and then later transformed into a consent order or a parenting plan. A good agreement at a mediation should really be strong enough to last until the following day, after a party has gone home, they've spoken to other family members about it and had a chance to sleep on it. If the agreement doesn't pass these tests, then it's usually not going to last in the long term. I've had a mediation fall apart at about 6:30 p.m. at night after the parties had been negotiating well all day, and unfortunately everyone was tired. It fell apart over a toolbox and a tea set. So I think it's really important that parties feel well, they're not tired, they've eaten during the day, and things are progressing smoothly and it doesn't go too long. And that's really the role of the mediator, to ensure that all those things are happening and that parties feel comfortable. They should not be signing anything if they're feeling upset at any stage during the mediation. So counselling, it's different to mediation, it's voluntary. Whether someone that is separated thinks they need it or not, it's usually a worthwhile exercise for them to speak to someone objective, such as a counsellor, about what's going on. Certainly, in most of my initial consultations, I do recommend that people see a counsellor if they're not already seeing a counsellor. Now, as counsellors, I'm sure you're often concerned about your client's confidentiality. Potentially, you are exposed to a subpoena. I could speak about aspects of confidentiality and how it applies in family law matters for a whole nother hour, but suffice to say it's important for counsellors to be aware of the possibility of their notes or themselves being subject to subpoena. So in the Baden Clay case, Jared and Alison had been to relationship counselling, and the counsellor was subpoenaed to give evidence of those sessions. That counsellor objected and cited Section 10E of the Family Law Act as to the confidentiality of those appointments. That was overruled by the Queensland Supreme Court judge, who found that confidentiality of the counselling was limited to proceedings and courts exercising jurisdiction under the Family Law Act. Next, I'll talk about some common terms that are used in family law and in the Federal Circuit Court and Family Court. I'm going to talk about an interim hearing, what is an independent children's lawyer, a family report, and a Section 11F child inclusive conference. So an interim hearing is a type of mini hearing which can be conducted in children's matters in order for the court to decide what should happen on an interim basis. An interim basis is the time between when the matter is first come before the court and when the matter can when the court can hear the matter at a final hearing or trial. So what can a client expect at an interim hearing? It's usually 2 hours or less. So there's no oral evidence. That is, parties are not cross-examined, not put in the witness box. It is based on the documents that have been filed in the matter. So that is the affidavits of the parties. It's based on submissions that are made from the bar table by legal representatives or by the party themselves if they're self-represented. Because of the type of hearing and there's no ability for the judge to test the evidence, any independent evidence that can be put before the court is very important. So what I'm talking about here is subpoenas that might be issued, for example, to doctors, other medical professionals, or the children's school, or the department, or any reports that may have been obtained prior to going to court. So after the judge has heard all of the evidence in the matter, they'll make an interim decision and issue an interim order to the parties. The parties are bound to follow that order until further order of the court. So what is an independent children's lawyer? They're a lawyer appointed by the court and chosen by Legal Aid Queensland from their panel to represent a children's best interests in a court matter. So not all children's matters before the court will have an ICL. An ICL can only be appointed by the court, either of the court's own volition, if the court has read all the material and they're concerned about it, or upon application by either of the parties. So what this means is that if one party wants an ICL but the court doesn't agree, then an ICL will not be appointed. So the role of the ICL is to ensure that all necessary independent evidence is before the court. For example, one party might issue a subpoena to the police about the other party's record but not their own. The ICL is there to ensure that all necessary subpoenas are issued and all reports are obtained, for example, family reports or psychiatric reports. It's worth noting that an ICL will not necessarily speak with the child or children whom they're representing. It really is up to the specific independent children's lawyer if they wish to speak to the child. Some do and some don't. I've found in Queensland mostly the ICL will choose not to speak with the child. In other states such as Victoria or New South Wales, they do speak with the children quite regularly. So one of the reasons why an ICL might not wish to speak to the child directly is because the child might make a disclosure to them, or they might indicate what their wishes are. And that's then putting the ICL in a position of becoming a witness in the case, which they would want to avoid. Family reports. So it is common in children's matters for there to be a family report. You don't have to have an ICL in your matter in order for a family report to be prepared. Now that report can be a privately funded report where the parties can choose to obtain a family report and they can equally pay for the costs of that report, and they can be quite expensive. It can be sort of in the realm of $4,000 to $5,000 roughly for a privately funded family report. Alternatively, the court themselves might make an order for a court-funded report, which is undertaken by one of the family report writers in the court. The report writer, amongst other things, will try to ascertain what a children's wishes are if the child is old enough. They'll meet with the parents and the children and any other important people in the children's lives, such as the grandparents that are actively involved or a new partner. So the interviews could be with the parent and children, and they can interview the children by themselves if the child's old enough. And then after they've finished the interviews, they might also inspect the court material, read any affidavits, etc., and then prepare a report. Usually the report will conclude with some recommendations about the matter. And those recommendations can include recommendations about what care arrangements they think would work best for the family and the children. Now, it's worth noting that the judges do usually rely quite heavily upon the report writer's recommendations in their decision-making process, but it is not the only evidence. The judge will consider all of the evidence, so the report writer is not the decision maker. Sometimes, instead of a family report, the court might order what's called a Section 11F report. It's a child inclusive conference. This is a shorter form of the family report process. The judge might order this type of report in urgent matters or matters where the court needs a quick glimpse into the family dynamics. A family report can take a couple of months to be prepared and come back before the court, whereas the Section 11F can be done quite quickly in a week to 2 weeks, for example. It is prepared by the counsellors at court, so it does depend on their availability. But it is hoped that at the end of the Section 11F report, it gives the court enough information to decide the next steps in the case or make some interim orders about care arrangements for the child or children. So next I wanted to just have a quick chat about some things for separating parents to bear in mind. Firstly, it is not trial by Facebook if you go to court. Even so, I usually recommend to clients that they shouldn't be posting details of their separation on social media. I'm always surprised about the number of people that have open Facebook pages, and there are times when a Facebook page can give something away. It's really best not to post anything on social media. Also remember that every matter is different, and I always say to clients, beware getting advice with a friend who's just been through a separation. Family dynamics are different, children are different, and different things work for different families. Another thing to be wary about is to not let the children decide on what post-separation parenting arrangements will work best for them. Yes, you can maybe test out children's wishes, but don't let them decide. It puts an enormous amount of pressure on children because children will usually want to please both parents. So they'll tell dad what dad wants to hear and they'll tell mum what mum wants to hear. It's an adult decision and to be made by the adults. Another reminder that by going to court, parent is handing over the decision making to the court. A judge does not know your family or your children. So if you can work it out by mediation or by family dispute resolution or by negotiating with the help of a solicitor, then that is the best way to go, acknowledging that it's not always suitable. Another thing to remember is it's not about you. It's about what is in your child or children's best interests. Now, I say this, there is one particular judge that really gets quite upset with parties when they appear before him and they say, I want this or I want that. He very quickly makes it clear to them that it is not at all about them. It is about their child or children. We finished a bit early today, but I wanted to thank everyone for attending. If you want to know more or there's something I didn't cover, please don't hesitate to contact us by telephone or email. Alternatively, if you have a more specific topic about family law that you want some answers to, please contact us. We can come to your firm and give a more in-depth presentation, so don't hesitate to get in touch. And just a reminder that we do offer fixed fee first consultations. So that means that your clients can be reassured if they come and see us that the fees won't blow out for that initial consultation. And we really spend as much time as we need to obtain all the information about the person's particular matter and to give them some advice and some options for resolution and different consequences that can happen from different options. Alternatively, if you have a client with you and they have a particular one-off query, please don't hesitate to give us a call or send us an email and we'll try to help you then and there for no fee. There's our contact details, and thank you once again for joining me this afternoon. I hope that's been helpful.